Mental Disorder and Criminal Law by Jesse Piccolo. Mental health definition. Um, each of the mental disorders is conceptualized as a clinically significant behavior or psychological syndrome or pattern that occurs in an individual and that is associated with the present distress or disability or with significantly increased risk of suffering death, pain, disability, or an important loss of freedom. In addition, this syndrome or pattern must not be merely an acceptable and culturally sanctioned response to a particular event. Whatever its original case, it must be considered a manifestation of a behavioral, psychological, or biological dysfunction in the individual. Neither deviant behavior nor conflicts that are primarily between the individual and society are mental disorders unless the deviance or conflict is a symptom of a dysfunction in the individual as described above. Problems with the definition is it's broad, it's vague, it's subjective. They recognize these problems, but it's difficult to remedy these issues because there's so many issues when it comes to people and the mental side of them. State conviction. The state can justifiably convict and punish a citizen in the criminal justice system if the agent has committed a crime, was responsible at the time of the crime, and therefore deserves punishment. The state can do this only if the defendant is competent in each stage of the process. Non-responsible agent. The state can civilly commit a dangerous but non-responsible agent. If the citizen is sufficiently predictably dangerous, if the criminal justice process cannot proceed until the defendant is restored and to the necessary competence. Mental health law. Mental health law is the area of the law that applies to persons with a diagnosis of mental illness and to those involved in managing or treating such people. Mental health law includes areas of both civil and criminal common and statutory law. Common law legal concepts include mens rea and insanity defenses. Statutory law usually takes the form of a mental health statute. An example is the Act of 1983 Providence Rules and Procedures to be followed in the treatment of mental illness. Mental health legislation. Largely used in the management of psychiatric disorders and developmental disabilities. A person does not possess the ability to act in a legally competent manner, requires treatment, needs another person to act in his or her own best interests. Insanity defense. A defense asserted by an accused in a criminal prosecution to avoid liability for the commission of a crime because at the time of the crime the person did not appreciate the nature or quality or wrongfulness of the acts. Defendant claims they are not responsible for their actions due to mental health problems. Voluntal insanity. Irresistible, impulsive. The defendant, although able to distinguish right from wrong at the time of the act, suffered from a mental disease or defect that made him or her incapable of controlling his or her actions. Common in crimes of vengeance, very few states allow this defense. Cognitive insanity. A defendant must have been so impaired by a mental disease or defect that at the time of the act that he or she did not know the nature or quality of the act, or if the defendant did not know the nature or quality of the act, he or she did not know the act was wrong. The vast majority of states allow criminal defendants to invoke the cognitive insanity defense.